Hi, my name is Barry Doyle. I'm a nursing home abuse and neglect lawyer in Skokie, practicing law throughout the state of Illinois. I'm also the author of Built to Fail, a free report which describes how the nursing home business model ultimately produces unnecessary injuries and deaths for nursing home residents. I'm here today to talk about a citation that the Illinois Department of Public Health issued to Arcadia of Danville nursing home after a resident there died of an untreated urinary tract infection. Now, one of the basic functions of nurses in a nursing home setting is to serve as the eyes and ears of the doctors. Doctors aren't there on a 24/7 basis, and they rely on members of the nursing staff to advise them when there are changes in the resident's condition, when the residents have abnormal lab results, when the residents are demonstrating signs and symptoms of infection. These are all things that require doctor notification. The idea behind this is that by notifying the doctor has the option then of either coming into the nursing home themselves to see the resident, issuing orders over the phone for treatment, or ordering the resident sent out to the hospital so that they can be examined by physicians at the hospital. Now, what happened here is a story of a failure to notify combined with a medication error. This resident was a hospice patient. And the fact that he was a hospice patient doesn't mean that he was actively dying, but he was at the end of life. And this was a gentleman who had a complicated medical history, which included a frequent history of urinary tract infections, including urinary tract infections involving drug-resistant organisms. And what's meant by a drug-resistant organism is this. Most infections are caused by bacteria, and bacteria will evolve over time to become resistant to certain types of drugs which are used to combat them, which are antibiotics. So, for example, most people have heard of MRSA, MRSA, and what that stands for is methicillin-resistant Staph aureus. Staph aureus is the type of bacteria. Methicillin was a type of antibiotic that used to be used fairly frequently to address infections that were brought on by the Staph aureus bug. So that's what MRSA means. It's MRSA, and over time, as the use of antibiotics has grown and evolved, organisms have too, and have become resistant to various kinds of organisms. And what happens then is when somebody has a history of having drug-resistant organisms, it means that it may be difficult to treat that particular patient with the standard array of antibiotics that might be used for a given type of infection. So during the course of this resident's admission, he was suspected of having developed a urinary tract infection. And there was an order given for him to take Levaquin. And Levaquin is an antibiotic. It's one of the kind of frontline antibiotics that gets used frequently in a nursing home setting, specifically for treating urinary tract infections. It's often used for other things, but you tend to see it very frequently with urinary tract infections. There was also an order given for a urinalysis with culture and sensitivity. And essentially what a urinalysis and culture and sensitivity test does, it confirms the presence of, yes, there's a urinary tract infection, but the sensitivity part tells you what drugs the bug or the bacteria are susceptible to. Because when you have a drug-resistant, a history of having drug-resistant organisms, not all the antibiotics are going to work as well as they should. So, this urinalysis and culture and sensitivity was ordered. In the meantime, the doctor had, based on the presence of the signs and symptoms of infection, ordered Levaquin to be taken with the expectation that would work. If it turned out that it wasn't going to be something that would work, then the doctor could simply adjust the antibiotic, and that's the point of having gotten the culture and sensitivity. But most often, these things it's called treating the infection empirically, based on what they expect the particular organism would be susceptible to, just based on the law of large numbers. So In this particular case, the urinalysis and culture and sensitivity was done. The results came back, and it showed that the organism that was causing this gentleman's urinary tract infection was in fact resistant to Levaquin. And Levaquin was the antibiotic that was ordered in this case to treat this urinary tract infection. So essentially the drug that had been ordered was one that wasn't going to be as effective as expected, given that the organism that was causing the infection was resistant to this particular drug. Now, this is an abnormal lab finding. This is something that would require doctor notification, especially since it would require a change in the regimen that the resident was receiving to treat this urinary tract infection. The problem was that call was never made to the doctor. The doctor was never notified that this abnormal lab result had come in, which showed that the drug that had been ordered for this resident wasn't one that was going to work. The nursing staff, charting for this resident over the next several days, noted the resident having changes in mental status, possible seizure activity. These are abnormal appearance of the urine. These are signs of a persistent, potentially worsening urinary tract infection. These are all things that in and of themselves should have required physician notification, because it serves as evidence that the treatment which had been ordered for this resident wasn't working. In the meantime, there was also a separate set of labs done, which came back with showing that the resident had elevated BUN, elevated creatinine, both of which are signs of dehydration, which is often associated with a urinary tract infection. Showed signs of elevated levels of ammonia, which is an adverse finding, which also requires physician notification. And it also showed that the resident had potassium levels which couldn't be detected at all. And this resident had been on a potassium supplement because he was on a diuretic, and essentially he was shedding his body's natural store of potassium as a result of urinating. And the supplement was intended to replace the potassium that was being lost. The problem is that when this resident went into hospice, the care of this resident, the management of this care went from the nursing home staff to hospice staff. And the hospice staff did not receive a full list of medications from the nursing home. So when this resident was on hospice, he wasn't receiving the potassium levels. So his levels of potassium were dropping at the same time he was beginning to suffer this urinary tract infection. And over the next several days after this abnormal lab came back, which the doctor was never notified about, the resident continued to show signs of increased lethargy, a fever developed. The resident was showing additional signs of changes in mental status, all of which are signs that this resident was in fact having a worsening infection until about two and a half weeks after this initial abnormal urinalysis came back. The resident passed away. Cause of death was related to sepsis from this untreated urinary tract infection and the declines that were associated with the loss of potassium and dehydration. So this was a very preventable death. Even though this was a resident on hospice, he wasn't expected to die imminently, but he was at end of life. He was medically frail, and the doctor who was interviewed by the state surveyor felt that the combination of these two things really did contribute to cause this resident's death. This is a death that was very preventable and would have been easily prevented by the notifications having been made as to the abnormal urinalysis as well as the abnormal labs that came in about 10 days later, as well as the medication error not having occurred. Between the two of these, this was simply too much for a gentleman who was already medically compromised to deal with on his own. I hope you found this interesting and informative. My name is Barry Doyle. I'm a lawyer practicing nursing home abuse and neglect work throughout the state of Illinois. We're happy to answer whatever questions you may have. You can feel free to call us at 312-263-1080. There's no charge for the call. I hope you've enjoyed this. Thanks for watching. Stu.